Welcome to Right Republic, a channel dedicated to providing a right-wing perspective of Indian politics. The right is usually right. Judicial reform in India, that'll be the topic of today's discussion. This is something that the Modi government should be able to do because it has the consensus among all parties, especially the Congress. To be clear, the Congress manifesto before the elections of 2019 has very good ideas for judicial reform. I would say Modi government should take it and run with it and own it because it is very clear in terms of what it wants to achieve, at least at a higher level. Today, let's focus more on what should be done at the level of the Supreme Court, and then we will also talk about how we deal with that in the lower courts like high courts and lower level courts at the state level. Now, at the level of the Supreme Court, there are 34 judges. The government has recently increased the number of judges. That should be fine. What I would say is we should increase that number to 37 judges. This is all suggested by Chidambaram, who has done very good work in terms of proposing these ideas, but he was also in charge of the Congress Manifesto Committee of 2019. So these ideas are very good ideas. He knows what he's talking about, having been a Supreme Court lawyer and also having studied these issues. So if there are 37 judges, what the government should do is the top 7 judges, the most senior among the Supreme Court judges, should be placed at the level of what we should call the Constitutional Court. So there should be 7 judges used to be called the Supreme Court and convert that into a constitutional court. This court should hear only constitutional cases and not any level of... This should not serve as a court of appeals. Now what happens to the remaining 30 judges? They should be placed in 5 or 6 benches across the country in what should be called as courts of appeal. This is a system they follow in the United States, and India should adopt that system so that these courts serve as appeals courts based on these decisions taken by the various high courts of different states. The cases should not go to the Supreme Court, rather they should land in these courts of appeal, and they can sit in either one bench of all judges or maybe 2 benches. If there are 6 judges, there can be 2 benches of 3 judges each. And any cases involving no constitutional challenges should end there at the level of courts of appeal. And once there is a vacancy at the Supreme Court by way of retirement or anything, the senior most judges from one of these courts of appeal should directly move into the Supreme Court. That would remove a lot of backlog at the Supreme Court level and finish many of the cases at the level of courts of appeal. So anything which does not involve constitutional challenges, we should just finish at the level of the courts of appeal. In addition, the government should revive the now defunct National Judicial Appointments Commission in some form or the other. Because last time what happened was there was no consensus between the legislative executive branch on the one side and the judicial branch on the other side. So the government should work with the judicial branch, the Supreme Court, and then have a consensus and make some tweaks to the original NJAC bill that was passed in Parliament unanimously, the constitutional amendment, and it was subsequently thrown out by the Supreme Court. Now they should take it up and work on a newer version of it. You can dilute it a little bit, and that can decide how judges are appointed. You can involve all parties, but also the judicial branch, because there was less involvement from the judicial branch the last time they framed these ideas. I think there should be some kind of consensus that can be evolved, and then they can work out this. And they can also include it as a consolidated bill to remove this Supreme Court as a court of appeal and make it as a constitutional court of 7 members, and then the other judges at the various courts of appeal. Now this has a good chance of passing because it has consensus among all parties, and they should work with the judiciary to ensure that they don't pose any roadblocks after the passage of these bills. That should work out. In addition, they can also increase the retirement age of the Supreme Court and the High Courts so that we can clear backlog. I think it's 62 now. They should increase it to 65, and that should also prevent these post-retirement assignments, either the judges ending up as governors or getting seats in the Rajya Sabha. There should be a ban on that. There should be a ban on any assignments like heading the Human Rights Tribunal. So these things should be taken out, or at least they should impose a kind of moratorium for 5 years or 10 years after the judges retire. So there is no quid pro quo in terms of the judgments they deliver. So that is something that these can be worked out. These are all ideas in the Congress Manifesto, and these are good ideas, and they have a good chance of gaining consensus at every level from all parties and also the judiciary. So one of the things that the judiciary always complains about is interference, and this would remove some of these conditions for interference if you remove these post-retirement assignments. But in addition, what the government should do is stand up to the judiciary. Executive orders which don't involve constitutional challenges, which don't challenge the Constitution, they should never be heard by the Supreme Court, and they should never challenge issues or decisions taken by the legislature or judiciary. For normal cases, the executive should be able to stand up for itself. The problem I have with Chidambaram's argument on this is, he being a Supreme Court lawyer, or lawyers like him and Kapil Sibal and Abhishek Singh, who are all members of the Congress party, they are the ones who are undermining the role of the legislature here. They voted for or against these laws in Parliament and then take up these cases like these farm bills to the Supreme Court. They are the ones undermining the role of the legislature by forfeiting some of their rights, lawmaking powers, to the Supreme Court. That is the problem I have with Chidambaram's argument, not this concept itself, but his hypocrisy. So this is something he needs to deal with, and even though he has written that the executive should be able to stand up to the Supreme Court, he should be the one who is following his own advice. Now, as far as the other high courts are concerned, again, as I said, we should increase the retirement age to 65, and the government should be involved less in terms of litigation. Government is the biggest litigant in this country. I think 46% of all litigations, the government is involved in some way or the other. And to be fair, the Modi government has done some good things in terms of reducing the number of cases, especially tax-related cases. They have actually waived off some of the smaller amounts in terms of taxes owed, and that has reduced thousands of cases. They should continue to do that. They also have created this NCLT, National Company Law Tribunal, and the Appellate Tribunal to handle bankruptcies. That has been decided. They have decided to put it in a special court. That is working fine. And also they have repealed more than 3,500 laws, old laws, which are no longer there. So these are good things, and they should continue along these lines, and we should be able to see that some kind of improvement in the next decade or so. But in addition, this pandemic has also given one more opportunity to make better use of technology. You don't have to get these witnesses, others, to come to the courts. You can do all of these by video conferencing. We can also invest more in digitization of records, and you can just grant immunity for all people involved in the case, all stakeholders. They should be exempted from personal appearances, because that's what has happened in other sectors. Judiciary should not be exempt, so we should use extensively video conferencing, Zoom and all that, and that'll create less delays. So if we do all of that, we should be able to reduce some of the cases which are lagging in courts. But there are more than 3 crore cases languishing at the lower courts, and the Supreme Court itself has thousands of cases which shouldn't be there. And finally, there should be some kind of limit imposed on public interest litigations. The government has to find some way of reducing these things, and nobody should be able to just walk in and then raise silly issues and put it in the purview of the Supreme Court. But one way of reducing that is converting that into a constitutional court. But we should make sure that by legislation we reduce these cases, because the same thing should not happen at the level of high courts or even courts of appeal. They should not be hearing these cases. The government should ensure that any legislation they bring forward covers that aspect to reduce these frivolous public interest litigations as well. To those who are more interested, they should have a look at the Congress Manifesto, which was released in April 2019 before the elections, and also have a look at P. Chidambaram's article in the Indian Express on the 30th of August this year. That will give some more details on what I'm talking about. Thank you.